Hello, this is Civil Liberties and Civil Rights, Section C lecture. Our prioritized standard is Government Civics 26. Objectively, we're going to examine how the 14th Amendment's Equal Protection Clause made possible civil rights reforms. Now, while civil liberties are actually concerned with protections against government actions, civil rights refers to positive actions the government should take to create equal conditions for all Americans. So again, civil liberties, things the government can't do to you. Civil rights involves them actively trying to prevent discrimination against groups. Now, civil rights are primarily concerned with the protection of rights for minority groups, with the 14th Amendment ratified in 1868 and its Equal Protection Clause providing the basis for most civil rights-based legal challenges since its passage. Now, in Scott v. Sanford of 1857, the Supreme Court declared in a 7-2 decision that blacks were not citizens. So regardless of if they were slaves or not, they said, if you're black, you're not a citizen of this country. Kind of the basics of this case. Dred Scott was born a slave. Him and his slaveholder moved to a state where slavery was illegal, and then they moved back to a state where slavery was legal. So then he went to the Supreme Court and said, hey, am I still a slave since I lived in a state without slavery? And the Supreme Court's answer was, well, excellent question, but only citizens are allowed to bring cases to the Supreme Court. And since you're black, you're not a citizen, so therefore you can't have your case heard in the Supreme Court. Based on that decision, the 14th Amendment was created to overturn this case, which stated that all people born in this country are citizens with full rights and are guaranteed equal protection of the laws, which is considered the Equal Protection Clause of the 14th Amendment. While Americans have been guaranteed equal protection since the late 19th century, many groups have continued to suffer discrimination, which has led to both legislation passed by Congress and legal precedents, not presidents, precedents created by Supreme Court cases that greater ensured equality among its citizens. Now, Congress has passed several laws that attempted to greater ensure equality among its citizens, including the Civil Rights Act of 1964, which came about as a result of after the March on Washington in '63. Now, the Civil Rights Act of 1964 prohibited discrimination in employment based on race, religion, gender, or national origin, and it also outlawed discrimination in public accommodations, facilities, and in schools. It also gave the Department of Justice the authority to bring lawsuits to enforce school desegregation. Civil Rights Act of '64, it also restricted tax dollars from going to organizations that discriminated. So if you discriminated in any way, you were forfeiting federal government money. It also created the Equal Employment Opportunity Commission, or the EEOC for short, to enforce fair employment policies. Now, the Civil Rights Act of 1968, this one prohibited discrimination in the sale or rental of housing based on race, religion, or national origin. Now, this law was actually extended to include restricting discrimination against gender in '74, and also people with disabilities in 1988, and also families in 1988. Now, this law is sometimes better known as the Fair Housing Act, mostly so that you don't confuse it with the '64 law. Congress also has passed laws that greater guarantee equality for specific groups, like, for instance, Title IX of the Education Amendments Act of 1972, and also the Americans with Disabilities Act of 1990. Now, the Title IX of the Education Amendments Act of 1972, this one declared that no person on the basis of sex could be excluded from participation in any education programs or activities receiving federal financial aid. Now, this law requiring equal funding actually led to dramatic increases in the number of females participating in both high school and college sports. Now, the Americans with Disabilities Act, this prohibited against discrimination against people with disabilities in various aspects of their everyday life, including in employment, education, and also access to public accommodations. So because of the Americans with Disabilities Act, that's why a lot of older buildings had to become more handicap accessible. Now, citizens with non-traditional sexual orientations and identities and same-sex couples have seen major advancements in their rights in recent years, especially through court rulings. For instance, same-sex couples claim that their right to equal protection of the law were violated by several states that ban same-sex marriage. Now, this refusal to allow same-sex marriage denied their ability to take part in medical decisions of their loved ones and also in their ability to adopt children. Additionally, if a child was a biological parent of one same-sex parent, then the non-biological parent actually had no legal parental rights. So that was some of the reasoning for why they wanted to change this. Additionally, several states also refused to recognize legal same-sex marriages performed in other states. So if you legally married in one state and then you moved to one of these other states that did not have same-sex marriage, it meant you no longer had these rights. Based on these issues in Obergefell versus Hodges of 2015, the court guaranteed marriage equality to all citizens regardless of sexual orientation in a 5-4 decision. The court said that only allowing the right to marriage to extend to only certain citizens was a violation of the Equal Protection Clause. Now, while states could not deny same-sex marriage due to the First Amendment the free exercise clause of the First Amendment, churches and other types of religious organizations did not have to actually perform these marriages. So if it was in opposition to their religious beliefs, they did not have to perform these ceremonies. More recently, the LGBT community has seen legal protections against hate crimes in 2009, allowing of openly homosexual individuals to serve in the military. That was in 2011. Technically, transgender people are still banned from serving in the military, but that is kind of a hot topic. Also, same-sex couples being allowed to adopt children. This was directly due to that 2015 decision, and other types of legal protections. Following the end of Reconstruction, Southern states passed what were called segregation laws that legally separated people on the basis of race, which have been more commonly known as Jim Crow laws, which has to do with a book called Uncle Tom's Cabin, but that's another story for another day. In Plessy versus Ferguson of 1896, the court ruled in a 7-1 decision that segregation did not actually violate the Equal Protection Clause as long as equal facilities were in fact provided. Now, the Plessy case established the separate but equal doctrine that further encouraged the institution of segregation, which remained in place until the 1950s. Now, while black citizens were provided facilities during segregation, they certainly were not of equal quality to those that were provided for white citizens. The Supreme Court finally heard a legal challenge to racially segregated public schools in Brown versus Board of Education of 1954. The court determined unanimously in a 9-0 decision that separate is inherently unequal and declared racial segregation in public schools to be illegal. Now, this marked the beginning of the end of state-mandated racial segregation policies. The Supreme Court continued to further strike down segregation laws, declaring the institution of Jim Crow unconstitutional. But that was the beginning of the end. Similarly, the Supreme Court declared gender-based segregation illegal with the integration of the previously male-only Virginia Military Institute in 1996, which was a part of the United States versus Virginia BMI 1996 case, which was a 7-4 decision, if you just love cases. A central focus of civil rights has been the extension of suffrage, which is the right to vote. So if you're ever asked if you're a fan of suffrage, the answer is always yes. Some people hear suffrage and they think it means suffering. That's not what it means. It means right to vote. As at the founding of the country, suffrage was reserved almost exclusively for adult white males that owned property. Now, by the mid-1800s, nearly all adult white males in every state had actually earned the right to vote. You didn't even have to own property anymore. You just had to be a white guy. The 15th Amendment, which was ratified in 1870, extended the right to vote to all adult males regardless of race. So at this point, if you're a guy, you can vote. The 19th Amendment of 1920, this extended the right to vote to all adults regardless of gender. This was reformed during the Progressive Era. And the 26th Amendment, which was ratified in 1971, this lowered the minimum voting age to 18 years of age. This effort was passed in part to lower the age based on World War II, where a lot of people felt like, hey, if you're old enough to fight, you should be old enough to vote. So because of that, it has been extended to a younger group of people now. While African Americans gained the right to vote in 1870, blacks were systematically prevented from voting for nearly another century in the South through many tactics like poll taxes, literacy tests, and grandfather clauses that were intended to disenfranchise blacks from voting, meaning they just wanted to make it very difficult to vote so that most African Americans would just not even attempt to try to vote anymore. One of those methods was a poll tax. This required voters to pay a tax to vote. Now, this excluded poor blacks from voting since most could not actually afford to pay for this tax. Now, this was often cumulative, where you actually had to pay for each year the tax was not previously paid. Also, if you did not bring your proof of payment to the polls to vote, then you would be forced to pay that tax again. Generally speaking, every former Confederate state had their own poll tax by the time it was 1904, but Virginia was actually the first to do so in 1871. Now, literacy test. This one required people to vote, or pass a test, rather, in order to vote. Now, this excluded blacks that were routinely denied an education and therefore more likely to be illiterate. South Carolina created the first literacy test in 1882, although as blacks got more education, they continue to try to make this more difficult to pass by virtually impossible literacy test. Grandfather clauses. Now, this one allowed a person to vote as long as his ancestors had voted prior to 1866. This one was created in part due to illiterate whites opposing the literacy test because, well, they didn't know how to read, so they also couldn't pass the literacy test. So even after grandfather clauses were declared unconstitutional, whites often were excused from having to take the literacy test. And even if they did take the test, it was still up to a white registrar, which was probably racist also, to determine if people passed or did not pass the literacy test. So whites often were passed regardless of their answers, and blacks often failed regardless of their correct answers. Now, it was not until the 1960s that African Americans were finally guaranteed an equal role in the electoral process with the passage of the 24th Amendment of 1964 and also the Voting Rights Act of 1965. Now, the 24th Amendment, this one officially banned poll taxes or any other types of taxes as a condition for voting in federal elections. It was not actually until the Voting Rights Act of 65, which we're going to talk about in a second, that poll taxes were actually prohibited in state elections. So the 24th only applied to federal originally, but the next one we'll talk about includes that at state level also. Also, Supreme Court finally declared poll taxes to be a violation of the Equal Protection Clause, in 1966. Now, the Voting Rights Act of 1965, this one officially prohibited literacy tests and put the entire registration process under federal control. So by taking the voter registration process out of the control of the state governments, this actually removed states' ability to create obstacles to blacks voting. Not until after the passage of the Voting Rights Act did the 15th Amendment truly guarantee the right to vote would not actually be denied on account of race. All right, that concludes Civil Liberties and Civil Rights, Section C lecture. Our prioritized standard again was Government Civics 26. Objectively, now you can examine how the 14th Amendment's Equal Protection Clause made possible civil rights reforms.